I'm Tim Eaton, President of the Chicago Bar Association. Welcome to the Chicago Bar Association's Justice and Law Weekly. As the baby boomer generation ages, the elderly population increases. This group is vulnerable for a number of reasons. However, when a loved one is stricken with Alzheimer's disease, unique and troubling issues arise. Here to talk about Alzheimer's and related issues is Kerry Peck, who is managing partner of the law firm Peck Bloom LLC. His practice concentrates in elder law, probate litigation, and estate planning matters. He has lectured widely on matters relating to the elderly and is a past president of the Chicago Bar Association. In 2013, the American Bar Association published Alzheimer's and the Law, a book co-authored by Mr. Peck. Welcome, Kerry.
Thanks for having me, Tim.
Kerry, before we get into the book and some of the legal aspects dealing with Alzheimer's, can you explain to us what is Alzheimer's?
Well, Alzheimer's is generally an illness that most folks consider to be a cognitive illness. And basically it hits individuals in the brain, unlike generally a physical illness, although as Alzheimer's progresses towards its end stage and slightly before then, there are many physical manifestations. But primarily it's an illness that hits our judgment, our ability to remember, our ability to make important decisions, and ultimately our ability to manage our day-to-day activities of daily living.
Now, is it a type of dementia?
It is a type of dementia, and it's considered primarily to be probably the dominant type of dementia, but there are different types of dementia. There's a vascular dementia, which is a result of strokes. Certainly there's an alcohol dementia for the individuals that are alcoholic. But Alzheimer's disease is its own specific type of dementia.
Now, until I read the book, I assumed, as I think most people have, that you don't die from Alzheimer's. Is that true?
Well, regrettably, I think that's a pretty common myth. Most of us, for many, many years, thought no one died of Alzheimer's. Unfortunately, as the disease progresses, today we've learned that, for example, one of the physical manifestations is an individual with Alzheimer's disease no longer can swallow. So frequently what happens is that food gets caught in their lungs, they suffer from aspiration pneumonia, and that may be a result of their demise or death. So, did they die of pneumonia or did they die of Alzheimer's disease? They certainly died of, something related directly to the inability to swallow any longer.
So we're talking about something that's very serious other than just forgetfulness.
Correct. We're talking about something that's very serious. It impacts on individuals' ability to drive, their ability to handle their day-to-day management of their funds, their money, write checks. Regrettably, we see many folks that are stricken with Alzheimer's become the subject of financial exploitation because they're mentally impaired and become good friends with people, give them their money, sign documents for them. So individuals that are cognitively or mentally impaired as a result of Alzheimer's disease really suffer in a variety of ways. And their families suffer as well. This is not an illness that it's, the patient standing alone. The family suffers tremendously when an individual no longer recognizes his or her loved ones.
Now, we all, as we get older, forget things, and that happens to everyone, whether they have Alzheimer's or not. How can you tell the difference in the early stages of Alzheimer's between someone who just naturally would be forgetting something or maybe unfortunately inflicted with the disease?
Well, Tim, when you and I were growing up, everybody said that our grandparents or people of that age, were becoming senile, and that was kind of, as you point out, part of the aging process. I think today the diagnostic tools that are available can separate, normal aging from Alzheimer's disease quite well. And typically that's done with a battery of neurological testing that's done. Most of it is judgment testing. For example, who would you call if you saw a fire? An individual with serious Alzheimer's disease is not able to respond to that. But your question relates to the kind of the normal progression. How do we know when we've crossed the line? And I think the answer is that we really should rely on the medical profession to tell us. Typically, another commonly used testing device is what we call a mini mental status exam, in which basic orientation questions are asked. Can you tell us who the President of the United States is, the Governor of Illinois? What season is it outside? What year is it? When I always add in, when did the Cubs win the World Series,
If they can remember that.
Right. Anybody that can remember that probably doesn't have Alzheimer's. Yes. But today, I think that, with neuropsychological testing and, going to a physician who has substantial insight into this area, it's a great idea. People normally start with their internist, and if the internist believes the circumstances warrant additional testing, he or she may refer them to a geriatric psychiatrist or very commonly to a neurologist. And, the major hospitals in our area, Northwestern, Rush, have memory centers that would conduct this type of testing for individuals that believe their loved ones are at that stage.
You obviously know a lot about it, and you wrote this book. What sparked your interest in it in the first place?
Well, it is an area that I deal with pretty much on a daily basis in our practice of law.
And you represent elder clients typically?
We represent elder clients frequently. We represent their families. We represent banks. We've been involved in the representation of a number of governmental entities and drafting legislation relating to financial exploitation and elder abuse. So typically these issues arise in the context of is mom capable of making her decisions? And of course, in the world of the practice of law where I'm at, those decisions may be, is mom capable of managing her affairs? Typically, these issues don't arise until often a husband has passed away very suddenly, the wife is left behind, and the wife relied in a normal marital relationship very heavily on her husband to make decisions for her, perhaps to manage her assets. And so much of our practice relates to a determination: is mom capable now to do an estate plan, or is mom capable of doing and making her own decisions and the management of her health care? Frequently, these health care issues bring the issue of Alzheimer's to the forefront. Mom has stopped eating. Mom has regrettably perhaps gone into a state of depression over the loss of her spouse. And so we deal with these cases in a scenario where the medical science and medicine, kind of cuts through the middle of it in terms of decision making. And again, those decisions could be as simple as, should I sell my home? Or as complex as, does someone understand that they're signing a complex, irrevocable trust document?
So I think you said in the book that sometimes it's the lawyer who recognizes the signs first before even the family or a physician does. And then do you refer them to see their family doctor?
We frequently encounter families that come to us in which, determination needs to be made, again, regarding someone's capacity. And that capacity may arise and, family comes in, mom needs a new estate plan, and we take a look at mom and engage in conversation with her and say, we're not sure mom has the ability to make that decision. We always start with the attending physician. We always want to get the clients and the family involved with the people that they're most familiar with and the people that are most familiar with the client's condition. Because the most attending physicians typically have long-term relationships, and they can give us an insight in terms of whether, our potential client or our client has the capacity to perhaps do a new estate plan. We frequently ask doctors to write us a letter indicating, Tim Eaton has the ability to do the estate plan, or alternatively, an individual does not have the ability. And then we get into, who should be the third-party decision maker. If mom doesn't have advanced planning, for example, what we call durable powers of attorney for health care or a durable power of attorney for property, and mom hasn't already named a decision maker for her time and when she's not capable of making those decisions, then we turn to the issue of guardianship. Does mom or dad need a third-party decision maker? And that's really, kind of a two-pronged inquiry. Does mom need a third-party decision maker based on medical evidence? If the internist is unable to tell us as to what his or her patient's condition is, or reluctant to do so. Some internists don't want to take adverse positions to their own patients, understandable, and often the internist will refer that patient to a neurologist or a psychiatrist. And if the family doesn't want to use, their internist, yes, we can refer out to, a myriad of resources that are available to assess an individual's capacity.
Now, in some of the case studies you have in the book, there seem to be instances where the family at times was actually more of a hindrance than help. Well, can you give us some examples of when that might be?
Certainly. We find in many of these cases that sibling rivalry often takes a life of its own. And what we find is that typically individuals come in and they tell us that they're concerned about mom's health, but unfortunately they're usually concerned about mom's money. And so what we find is that the siblings frequently get in the way of each other in terms of setting out their own agenda to take control of the management of the family's wealth or the family's assets, instead of making sure that mom gets the proper care she needs, mom lives in the proper setting. Alzheimer's patients regrettably lose the ability to live alone, and that comes to the forefront very quickly. They typically require, 24-hour-a-day, 7-day-a-week supervision. Sometimes that supervision and care can be placed in their home if the family has the resources and the family cooperates. But more often than not, when you say the family gets in the way, one member of the family says mom should live in her house, one family member says mom should live in my house, and another family member says mom should live in a nursing home. So we find that, there's a lot of conflict in those kind of scenarios. What we don't want is mom left at home leaving on the stove and killing herself, burning down the house, and if she lives in a, condominium, affecting other people in the community.
You had touched upon this earlier, but apparently there's a number of legal documents that can be considered to help protect the person that has this disease. I think you've mentioned powers of attorneys, guardianships. Can you walk us through some of those so everyone can hear just what there is out there to protect people?
Absolutely. It's a great question. Here in Illinois, we have documents that are typically kind of generically referred to as advanced directives. And it really means advanced planning. So for example, we recommend, and I think this relates not just to elderly people, this relates to anybody over the age of 18. Today in Illinois, we have two types of devices, two types of documents: a durable power of attorney for health care and a durable power of attorney for property. What's the concept? The concept is that I name you, Tim Eaton, Kerry Peck names Tim Eaton to manage my health care when I'm no longer capable of making those decisions on my own. Now, the important consideration here is I must be competent when I name an agent to make those decisions.
And who decides whether you're competent?
Well, great question. Great question. In most circumstances, the competency of an individual to execute certainly a durable power of attorney for health care is presumed. Why? Because under federal law, what we call the Patient Self-Determination Act, today when you're admitted to a hospital, even for an outpatient procedure, or you're admitted to a long-term care facility, a nursing home, you will be asked by the staff upon your arrival, do you have a power of attorney for health care? And the power of attorney for health care focuses on your decisions while competent, to exclude the type of medical treatment you don't want. So, for example, if your religious beliefs prohibit you from receiving blood transfusions, when the document is prepared, you would strike, I don't want to receive blood. The crux of the document focuses on, do you or don't you want life support when you're no longer able to express your opinion regarding the use of life support. So the document focuses on life support decisions and, organ donation decisions. Do I want to be an organ donor when I can't express an opinion any further? Do I want to be placed on a ventilator? Do I want to be placed on the equipment today that allows us to live longer? And I say live, quote unquote, because each of us come to those decisions as to whether we want life support based upon our religious training and our ethics and our morals. These are decisions that should be made in advance outside the courtroom.
And these are documents we all should have, whether we have potentially have Alzheimer's or not, correct?
Absolutely. Absolutely.
And are the people that, when you're talking about guardianships, are guardians of either over the person or the property usually family members? Is that typical?
They are usually family members, yes. They are usually family members.
And what if a person, their spouse has passed away, they have no children? Who would fill in that type of circumstance?
Well, there are government entities that fulfill that role. In Cook County, we have a very large Cook County Public Guardian's Office. We have at the state level a much smaller Office of the State Guardian. In addition, there are a variety, probably in Cook County, maybe 6 to 10 not-for-profit guardianship agencies that are regularly appointed by the probate court as guardian of the estate, as you point out, management of assets, or guardian of the person, management of health care decisions. So typically people rely on their family. Typically the court will appoint a family member, assuming a family member demonstrate that they have the capacity and the competency to do so. The court will not allow a family member to manage a large sum of money. So if an individual, usually in Cook County, has an excess of $1 million, in many cases the court will recommend the appointment of a bank to manage those assets.
Now, also, you touch upon this in the book. There are instances, unfortunately, of abuse
Right.
by guardians, family members. What type of things occur that you try to correct through either guardianships or documents that you mentioned?
Well, often we see scenarios in which, regrettably, caretakers, one-on-one caretakers that are isolated with an older adult in generally a home setting or a condominium or an apartment, take advantage of that older adult. They frequently withhold medication, they often withhold food, and basically it's an exchange for the signature on documents transferring wealth. So we often see caregivers heading over the currency exchange with a check that's been written by an older adult who might be afflicted with Alzheimer's disease. And of course, the caregiver says the older adult gave me a gift, and the older adult who, has Alzheimer's disease has no memory or recollection. Typically what we would do in that kind of scenario, if brought to our attention, is we would have the older adult promptly evaluated, mental evaluation to determine their capacity to make decisions. If they do not have the capacity to make the types of decisions in which they've been exploited, maybe they gave money to a caregiver to buy a car, we see that with unfortunate regularity, then we go into court and ask that the court freeze that individual's assets, by way of what typically would be an injunctive proceeding, and make sure that the caregivers can't get any more of those assets, try and recover the assets back, and have a guardian appointed for the older adult, both to manage their affairs financially as well as presumably health care.
Something that I found very touching and almost sad was the book points out that so many times this abuse, or where these individuals are being taken advantage of, is not reported because the person wants to keep the company of the guardian or the family member, so they're reluctant to report it in fear that they may leave them or will have no longer contact. Have you run into those types of situations?
We run into those situations, Tim, on a very regular basis. Unfortunately, much abuse of older adults occurs by family members. And the statistics show us that family members typically are children of older adults or grandchildren of, the older adults. And when confronted with the abuse, if the older adult understands the circumstance, they are very reluctant and usually do not get involved with reporting the abuse that has befallen them by a son or a daughter or a grandchild. The answer is really very simplistic. I'm not sending my child or grandchild to jail.
How often do lawyers actually become the guardian, or is that even possible? Is there situations where the lawyers have been accused of taking advantage of elder people or people who have Alzheimer's?
Well, unfortunately, yes. We do see cases in which lawyers take advantage of older adults. Usually that's in the context of converting their money from perhaps real estate transactions or estate scenarios. The Attorney Registration and Disciplinary Commission is constantly vigilant and regulating and disciplining lawyers that engage in that type of conduct. Lawyers generally do not become the third-party decision-maker guardians for an older adult. And I think that that's probably good practice because there are professionals that are more attuned and more educated in the world of being a guardian than we lawyers.
One thing I noticed about the book, and I've mentioned this book obviously numerous times during the interview, where can you get a copy of the book if people are interested in getting a copy of?
The book is available through the American Bar Association, and their website is shop.org, and the book can be purchased through the American Bar Association.
It's very interesting. And one thing I also noticed in the book is that there's a foreword by Scott Turow, the famous author. How did he come to write that foreword? How do you know him? And please give us a little background on that.
Well, Scott and I go a long way back. We were reminiscing that we had a case, I think, over 30 years ago, and Scott was kind enough to write the foreword. He owed me a favor, and this was the return of the favor, and I'm quite grateful. The foreword, I think, is very compelling. Scott has recently published a new book called Identical, and he opens the foreword with a scene out of his book Identical, which is a book about identical twins and, of course, a murder mystery thriller. And in the foreword to the book, Scott opens with the scene from Identical in which a homicide detective is interviewing a witness to a murder that's occurred decades earlier in time. Unfortunately, that witness has Alzheimer's disease, and the witness is not capable of answering the questions posed by the homicide investigator. Scott then seamlessly, as only he can do, moves from his new book, Identical, into revealing that his mother suffered from Alzheimer's disease, and he relates the impact that illness had on his family and calls Alzheimer's disease the scourge of our times. So I'm very grateful to Scott for writing this foreword and for his interest in the illness.
So this was very personal to him.
Yes.
Let me ask you, is there a cure in the near future, do you think, for Alzheimer's?
Well, unfortunately, there doesn't appear to be a cure on the horizon. There is some great research going on in Alzheimer's disease. There are some great trials going on with new medication that may or may not have an impact on Alzheimer's disease. Today, one can actually engage in what's called biomarking testing to determine if one has a propensity for Alzheimer's disease. The standard practice today is to take a look at your spinal fluid. It is not something that I'm prepared to do, but there are certainly advances. The Alzheimer's Association is raising money on a daily basis to fund research. The Alzheimer's Association today's primary goal is to fund research. And for those of your viewers who unfortunately have a loved one afflicted with Alzheimer's disease, the Alzheimer's Association is a terrific resource with support groups and information that helps folks address the day-to-day problems of dealing with Alzheimer's disease.
And in fact, traditionally they've been reluctant to even diagnose it, but I understand now that they do more often diagnose it.
You know, typically I am told, and I'm told by a number of physicians, that other physicians prefer not to diagnose their patients with Alzheimer's disease. It really is very, very tragic news to a family, and to preserve the relationships, doctors appear to be reluctant to do that.
Thank you, Kerry. Kerry Peck, thank you so much for educating us about Alzheimer's disease and how the law can help protect loved ones with Alzheimer's. I'm Tim Eaton. Thank you for watching the Chicago Bar Association's Justice and Law Weekly.